The Supreme Court judgment declaring that monies due to the local government should be paid directly to them is at variance with the provisions of Section 162 of the Constitution. This is the view of a senior legal practitioner, Jiti Ogunye. Also showing on the program, Nigerian lawyers go to the polls to elect a new president of the Nigerian Bar Association as Senior Advocate of Nigeria, Yakubu Mekiel's tenure gradually winds down. Plus our weekly recap of the top trending stories in the news. Hello and welcome to Law Weekly. I am Shola Shrieli. Two recent developments have brought back the debate on whether Nigeria runs a proper federal system. First, the Supreme Court judgment on local government autonomy and the negotiations for a new national minimum wage. I began my interview with Jiti Ogunye with his views on these developments and its implications on true federalism.
Unfortunately, we will not be running a true federal government, and that's why a lot of people have been calling for true federalism, fiscal federalism, state autonomy, decentralization of powers, and so on and so forth. And these had a historical foundation or root. The First Republic was fairly a proper federal state. The regions controlled their resources, and the revenue sharing formula at that time was that the region will retain a larger chunk of their internally generated revenue and will give a portion thereof to the central government for running. But with the advent of the military in 1986, and in particular the attempt through the unification decree of Ironsi to turn Nigeria into a unitary state and thereafter, which was rejected politically by Northerners and everybody then, but which was perpetuated when Gowon came in the face of a civil war and so on and so forth. At that time, a number of laws had been made, to take over all the resources in the state to the center, and then to reverse the revenue sharing formula, with the federal government now receiving that revenue and then distributing it to the states. So it's a fact that Nigeria has not been a true federal state. And that's why, as I said earlier, people have been calling for true federalism. Unfortunately, most of the people who are calling for that now are old. Many Nigerians, of today, perhaps were born after the distortion of the federal structure of Nigeria. And so they felt that what we have, or what we had now, is perhaps the best. And what we've seen in recent times is that in spite of mouthing true federalism, restructuring, decentralization of powers, when politicians get into government, rather than keep faith with their promises, they start taking decisions that will further centripetal forces and make Nigeria to be more unitary than it already is, even though it pretends to be a federal state.
So let's go back to that judgment on local government autonomy and its implications on true federalism. How essentially do you interpret the judgment?
The highlights of the judgments I've read and the reliefs that are granted by that judgment. I know that many Nigerians have held the judgments. Politicians at the local government level who are being suffering, quote and unquote, under the yoke of the governance are very happy with the judgment. Their own interpretation of the judgment is fiscal. It's fiscal, that more money will come into their hands now, and they will take responsibility for spending the money, and state governments and state governor will not dictate to them how the money will be spent, or take the money in the name of pursuing projects in the state while starving the local government of funds. It is my considered view, an humble view, that the decision of the Supreme Court on this matter is a misback. Largely, the judgment comprises two planks. One on the illegality of caretaker committees in local governments. And the second plank is on the issue of statutory allocation to local government. My view is that on the caretaker committee conundrum, the Supreme Court is quite right. Now, about the funding of the local government. Section 162 of the Constitution makes provisions on how revenue collected into the federation account shall be distributed amongst the tiers of government. That to be taken by the federal government, there is no problem about that. That to be taken by the state government, there is no problem about that. That to be taken by the local government, on paper, according to those provisions, there is no problem about that, or there shouldn't have been any problem about that. The relevant provisions under that section, I mean the subsections, is very clear that a joint account shall be established at the level of the state, into which statutory allocations, revenue shall be paid. There are two tracts of revenue into that joint account, two lines of revenue. Revenue from the federal government and revenue from the state government, meaning that both the federal government and the state government have a duty to pay revenues into that joint account, from which money for the benefit of the local government, shall be allocated or distributed. Unfortunately, at the level of the state government and their governors, overbearing governors, have been, abusing that power of holding the purse via that joint account. And, they've been taking money meant for the local government, from the local government. And this has been a serious issue. My view is that the decision or pronouncement of the Supreme Court on that are not in accordance with the clear provisions of the Constitution. And hey, if I may therefore ask, for states that are created LCDs, and virtually all the states in the South have done that, now, including Lagos State, where you have LCD, how would they now be funded? And talking about poetic justice, it was this president that created LCD in Lagos in defiance of the federal government, for which Lagos State suffered a lot from the hand of an overbearing federal government, headed by President Olusegun Obasanjo, because their local government funds were seized for about 3 years. Okay? And it was when Obasanjo left eventually that they had the money. He wanted to kill those local governments and all that. So those LCDs now that the Supreme Court had made this judgment, paid directly to local government. So by what instrument will those local government who have received their money directly, by what instrument would a portion or fraction of their money that they have received directly be now divided and given to those LCD to survive?
Not recognized by the Constitution.
They are not recognized by the Constitution. They are not recognized by the Supreme Court now via this judgment. How would they spend the money? Without, committing contempt of the Supreme Court in doing so. So I understand the argument. I understand that, yes, you don't want a situation whereby money meant for, And for those who are saying that this will bring developments to the grassroots, yes, money will circulate in grassroots. This is what is the money that is given to the state from the federal government and the one that the state generates. How much has it led to development at the level of the states? Have we not seen a situation whereby the money that's even meant for the federal government is also stolen at the level of the federal government? So at every level you've seen corruption, taking a large chunk of the revenues and money available to any tier of government. So it is not guaranteed or given that with this judgment, once the money goes to every local government, they will now devote or dedicate that money to developing their local government. As a matter of fact, what we are going to have is that more and more local government chairmen and their members will now be trooping to Abuja and Lagos to have a piece of Lagos by buying properties there. You know, so it will only have led to a situation whereby corruption will now be democratized. And so, if people say that, yes, it's okay, even if they steal it at that level, I have to run there at the local level. If that's what is intended, maybe this may promote the kind of development that we're talking about, that people are mouthing and all that. So, my view is that this decision of the Supreme Court, the one that we're talking about now, is bereft, profound respect, of federalist sensitivity. And so now, we're going to have a situation whereby we'll have a jigsaw. The Constitution on paper is saying one thing. The Supreme Court has said another thing.
So with what you said, the Supreme Court is saying one thing and the Constitution is saying another. How do you propose that we have a resolution that makes both of them come into harmony? Well, one thing that is possible is for the National Assembly now to do a tailist thing. But so the Supreme Court has done this, so let's go and amend the Constitution in conformity with the pronouncement of the court. The other thing is to leave it as it is and then perpetuate the conundrum where the Constitution is saying one thing and then the Supreme Court has pronounced another thing. And so that disharmony will then persist, and students and scholars of constitutional law will be left to analyze and analyze and analyze and analyze, and then we'll see what will happen in the future. There's a bill to establish the National Independent Local Government Electoral Commission, which has scaled first reading in the Senate. What are your impressions of that bill? Again, that is another problem. So to even conduct local elections, so you now need a federal agency, another bureaucracy. So that would then be going throughout the length and breadth of the country to be conducting local government elections. Now, regardless of local particularities, we then arrive at a situation whereby they say, no, they want uniformity of tenures all over the country, so that they'll be conducting that election on the same day. Okay? So I'm saying that Nigeria, if that's what Nigeria really wants, a unitary state from the beginning, let's sit down and have it. But those who go into government now to tinker with the structure of Nigeria had no such mandate from the people. All this thing they are doing was not on the ballot. So do you think it's geared at buying loyalty ahead of the next general elections? When in a political system, when you push monies that state governors are illegitimately taken, are illegally taken into the hands of the local governments, those politicians at the local government level, at the grassroots level, are bound to be grateful to the person who has made that to happen. And political benefits certainly will come from that. So your guess is as good as mine, whether there was a political calculation behind it, whether there was a political agenda behind it. But what I know is that politicians, being who they are, at the local government levels across the entire country, is big celebration now. So we will see what will happen. Whether the ordinary people that unfortunately have joined the celebration that, oh, they are now going to receive the dividends of democracy at the grassroots level, will receive it by the stroke
of this judgment? I don't think so.
Welcome back. As Nigerian lawyers go to the polls to elect new national officers for the Nigerian Bar Association, the Electoral Committee has promised free, fair, credible, and inclusive elections. Chairman of the Electoral Committee, Senior Advocate of Nigeria, Olusegun Abimbola, also asked lawyers to cooperate with the electoral body to achieve successful elections. Mr. Abimbola spoke at the Manifesto Day and presidential debate for all candidates contesting. 3 candidates, Senior Advocate of Nigeria, Afa Mosigwe, Senior Advocate of Nigeria, Chukwuka Ikwazom, and Tobena Erojikwe, are contesting the position of President of the NBA. Whoever emerges after the polls will take over from outgoing President, Senior Advocate of Nigeria, Yakubu Mekiao.
It is Manifesto and Presidential Debates Day ahead of the Nigerian Bar Association's 2024 election. Legal practitioners, senior advocates of Nigeria alongside candidates have converged for the presentation. Channels Television's head of Judiciary Desk, Shola Shoele, moderates the presentation session. Each candidate had 3 minutes to present their manifestos and answer questions.
The candidates shall abide by the set time, and we have a timer that will be up on stage to guide all our candidates.
3 candidates are running for the seat of the presidency, and each of them speak on their laid-out plans for the association.
What decisive stance will you take to strengthen the independence of the judiciary and ensure its integrity? And how will you address cases of judicial impropriety where there's a breach of judicial code of conduct?
One of the things that the MB under my leadership will do to ensure the integrity of the judiciary is that we're going to hold judges accountable. When I was making my initial presentation, I did say that the Nigerian Bar Association under my leadership will institute a nationwide court monitoring system to observe what is happening in our courts. Beyond that nationwide court monitoring, we're going to follow developments in the judiciary. And whenever we see that a judge has done something that could amount to judicial misconduct, the NB under my leadership will not have any hesitation whatsoever to take up that matter, do a petition to the NJC and follow that petition to the logical conclusion to see that appropriate punishment is meted to the erring judicial officer. Because the reality is that whether we like it or not, what happens in the justice sector impacts not just the legal profession but the entire country. And that is why, as members of the bar, we must stand up at all times to hold our judges accountable.
So I will propose constitutional amendment to overhaul the composition of the NJC, the appointing powers of the CJN, the chairmanship of the continued chairmanship of the CJN, of both the FJSC and NJC, and the continuing allowal of NBA representatives to be part of the disciplinary process. But above all, we must appoint the right persons to the bench. We must try to find solutions that ensure that we reduce judicial corruption to the minimum. And we must do things that does not expect our judicial officers to politicians. But we must take steps to cure the malady in the judiciary. We must ensure that the disciplinary powers of the NJC are transformed to an independent body that is able to exercise their powers independently and ensure that people have confidence in the ability to discipline people. Because you see, same facts, same circumstances, different results. As NBA president, I must push for reforms. I must make sure that we follow up cases where judges have been found to be corrupt, or where judgments or decisions by a judge give indication that is either the judge is corrupt or was corruptly induced or the judge is incompetent.
I was, up until a few weeks ago, a member of the NJC. So I've had a direct conversation about this corruption thing. And what the judges always say is, you lawyers talk about corruption in the judiciary, for instance. Who are the corrupting influences of the judges? That's the kind of conversations that we have. Now, on the immediate term, I had talked about a court monitoring scheme that we had put in place. What it means is that the NJC, the Supreme Court, the Nigerian judiciary has actually endorsed that court monitoring scheme. And I think that the first thing any president of NBA will do or should do is to make sure that that scheme is enforced. And make sure that as we're enforcing it, we are telling them, you sign this communique at the end of it. You've mandated us to do it. At the end of the day, bench or bar, The legal profession in Nigeria is one, and we must fight to the extent possible of the bar to deal with it. As president of the bar, I will sit in the appointments committee of the NJC. I will sit as a member of the NJC, and I will make sure that justice, equity, and fairness is enthroned.
2 candidates are contesting for the position of the General Secretary, while 17 others are contesting for the national executive seats.
And just before we go, a quick look at some of the major court stories we tracked this week.
We begin with the report that the Federal High Court, Abuja, has reinstated the impeached Deputy Governor of Edo State, Mr. Philip Shaibu, back to office. Delivering judgment, Justice James Omotosho declared his impeachment by the Edo State House of Assembly as illegal, unconstitutional, null and void. The court held that the said impeachment was in gross violation of the provisions of both sections of 188 and 35 of the 1999 Constitution as amended. Aside from restoring him to office as the Deputy Governor, the court held that all his salaries, allowances and benefits should be paid to him from April 8th, when he was illegally impeached, until the expiration of his tenure. The court also issued an order of perpetual injunction restraining Governor Godwin Obaseki and the Edo State House of Assembly from stopping Mr. Shaibu from performing the functions of his office. Staying at the Federal High Court, the same judge has dismissed a suit by the impeached Deputy Governor of Edo State, Philip Shaibu, and others seeking to void Asue Ighodalo's nomination as the candidate of the People's Democratic Party in the forthcoming governorship election in Edo State. In his judgment, Justice Omotosho held that the suit, which challenged Mr. Ighodalo's qualification on the grounds that he allegedly forged his voter's card, was statute barred. Justice Omotosho held that the suit, being a pre-election case, was filed outside the 14 days allowed under Section 285, subsection 9 of the Constitution. The judge also held that even though forgery or non-possession of voter's card was a disqualifying factor under Section 182 of the Constitution, the plaintiff failed to prove that Mr. Ighodalo forged his voter card as alleged by the plaintiffs. The judge dismissed the case for lacking in merit. Another judge, Justice Hamza Muazu of the High Court of the Federal Capital Territory, Abuja, has rejected an application by the former governor of the Central Bank of Nigeria, Godwin Emefiele, for permission to travel to the UK for medical checkup. Justice Muazu, in a ruling, held, amongst others, that Mr. Emefiele failed to supply sufficient material to show that the medical trip was essential and unavoidable. Justice Muazu found that while Mr. Emefiele claimed there was an invitation for him to travel to the UK for medical attention, he failed to tender a copy of the said invitation in court. The judge also found that Mr. Emefiele did not show that his ailment could not be attended to in the country. In Kaduna, the Federal High Court has reserved judgment in the suit filed by the immediate past governor of the state, Nasir El-Rufai, seeking the nullification of the report by the ad hoc committee of the State House of Assembly, which indicted him and his administration in an alleged 423 billion naira fraud. The former governor had in June 2024 filed a fundamental rights case at the court challenging the House report on the grounds that the House did not give him a fair hearing during his sitting. In the suit, Mr. El-Rufai, through his lawyer, Senior Advocate of Nigeria, Abdul Hakim Mustafa, is asking the court to declare the Assembly's report as null and void. Counsel to the Kaduna State House of Assembly, Senior Advocate of Nigeria, Femi Falana, argued that the court lacks jurisdiction to adjudicate on the fundamental rights cases filed by Mr. El-Rufai or dismissed the report of the Assembly based on its constitutional mandate. The Kaduna State Commissioner of Justice, Senior Advocate of Nigeria, Sule Shaibu, has also asked the court to dismiss the case for lack of jurisdiction. After listening to the lawyers in the suit, the presiding judge, Justice Rilwan Aikawa, says the date for judgment will be communicated to the parties involved. And we round off with the report that the Court of Appeal in Abuja has dismissed an appeal by the suspended Deputy Commissioner of Police, Abba Kyari, seeking to quash the drug trafficking charge filed against him. In its judgment, a 3-member panel of the appellate court dismissed Mr. Kyari's appeal for lacking in merit. Justice Adebukola Banjoko, who read the lead judgment, held that there was no reason to tamper with the findings and conclusions reached by the trial court on March the 22nd, 2023. Other justices on the panel, Justice Peter Obiora and Justice Okon Abang agreed with the lead judgment.
And that's the program for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shieli. Thank you for watching, and see you next time.